She left one review. It destroyed a $340,000 business partnership. A single online review, 4 sentences, and by the time the dust settled, 2 lives, 1 collapsed business, and $340,000 were all on the line. They had been partners for nearly 6 years. The plaintiff and the defendant had built what friends called an unlikely success story, a boutique e-commerce operation selling handcrafted leather goods out of a converted warehouse on the edge of a mid-sized industrial city. The plaintiff handled sourcing and supplier relationships. The defendant managed the online storefront, customer service, and brand reputation. By March of the year, everything unraveled. The business was pulling in just over $800,000 annually. Then they dissolved the partnership, split the assets, and went their separate ways. Amicably, they both said at the time. Amicably, it turned out, was a generous word. 8 months after the split, the plaintiff had relaunched under a new brand name, carrying similar products, targeting the same customer base. Sales started strong. Then, seemingly overnight, they collapsed. The plaintiff began receiving messages from wholesale clients citing concerns about his professional reputation. 2 long-term buyers canceled contracts without explanation. A third forwarded something that made the plaintiff's stomach drop. A Trustpilot review posted under the username Verified Buyer 2019, describing his former business in lurid detail. The review alleged financial impropriety, claimed suppliers had been stiffed on payments, and suggested the plaintiff had a history of, quote, abandoning business partners when things got inconvenient. It had been shared in 2 private Facebook groups for small business owners in their industry. Within weeks, it had been screenshot and circulated further. The plaintiff traced the account, hired a digital forensics consultant for $4,200, and the IP address pointed to a cafe 2 blocks from the defendant's home. The plaintiff filed suit for $340,000, representing $180,000 in estimated lost contracts, $95,000 in projected revenue decline over 18 months, and $65,000 in reputational damages. His attorney argued this was a calculated act of sabotage, that the defendant, bitter over the dissolution, had weaponized a false narrative to kneecap a competitor. Witnesses testified that the plaintiff had always met supplier obligations. 3 vendors provided written statements confirming timely payments throughout the partnership. The plaintiff himself took the stand visibly emotional, describing the moment he realized former colleagues were avoiding him at a trade show. "I built something honest," he said, "and someone burned it down because they could." The defendant's attorney was measured and methodical. She acknowledged her client had created the account, but argued the review, while harsh, was constitutionally protected opinion, not defamation. More importantly, she argued it was substantially true. The defendant took the stand and described a final year of partnership marked by financial decisions he claimed were made without his knowledge. Inventory purchased on shared credit lines. A supplier advance the plaintiff had taken and never disclosed. He had documentation, internal messages, bank notifications, a supplier invoice paid 6 weeks late that the plaintiff had never mentioned. He wasn't lying, his attorney argued. He was warning others. And then came the forensic accountant. The defendant's team had subpoenaed the business's historical records as part of discovery. What the forensic accountant found was not what either side expected. Buried in the transaction history from the final 8 months of the partnership was a pattern of small withdrawals, between $200 and $800 at a time, totaling just over $22,000, traced to a payment account the plaintiff had sole access to. None of it was documented. None of it was declared in the dissolution agreement. The accountant testified it was consistent with quiet, sustained embezzlement. Not enough to be explosive, enough to be deliberate. The courtroom shifted. The plaintiff's attorney objected repeatedly, argued it was irrelevant, argued the financials were outside the scope of the defamation claim. The judge allowed it. The jury had already heard it. The judge ruled in favor of the defendant. The review, while damaging, was found to be grounded in a factual basis the plaintiff could not credibly refute. The claim of financial impropriety, however unpleasant its delivery, could not be proven false when the plaintiff's own records suggested otherwise. The $340,000 claim was dismissed in full. Court costs of $18,400 were awarded to the defendant. What followed was complicated. The plaintiff appealed unsuccessfully. The $22,000 discrepancy was referred to a civil recovery process, though no criminal charges were filed. The defendant's business never recovered the momentum lost during the litigation. The legal fees alone exceeded $60,000. Both men, by most accounts, walked away diminished. The review is still live, and that's the question this case leaves behind. If something damaging is true, does it matter how it was said or why?